Welcome to the TCS event on India's Digital Personal Data Protection Act 2023 and its impact on your data privacy strategy. My name is Bhatla and I'm the marketing lead for TCS MasterCraft DataPlus and your host for today's event. In this event, we have our industry experts who would discuss the key areas pertaining to the India's newly passed data protection regulation and its impact on Indian organizations. The panel will provide insights from their experience of data privacy practices over the years. In addition, this virtual event will highlight the very importance of a technology-driven approach, to enable and ensure you have your enterprise-wide data protection and the regulatory compliance. But just before we begin, let me take a minute for you to understand this virtual platform. So if you see at the bottom of your screen, you will see a row of widget icons. So these control the various windows which are resizable and movable by clicking on the arrows in the top right corner. So feel free to move them around to create the layout that best works for you. My suggestion would be just maximize the video window so that you can view the speakers and the panel discussion, and have the Q&A ready, the Q&A panel ready, so that you can quickly post a question that should come to your mind. When I'm talking about Q&A, please remember you don't need to wait until the end of this session to submit your questions. Please keep submitting them at any time. Another important thing, we have a reactions button, which you can use to express your feelings towards the content that we are being shared through various emojis. And if I may request, please make sure to fill the event survey. You could also do this during the event. Finally, a very important point, in case you've disconnected or your screen freezes during the session, just try to refresh your Chrome browser, the preferred browser for this session. In most of the cases, that should help you fix things. Or please raise the concern in the chat box. We have our tech for any login or tech-related issues, and we have our support team who will try their best to help you and get you back. So we're ready with all this, and I hope everyone's having all set with the browser and the understanding. So let's start off this exciting session. First, I would like to welcome our first speaker for today, Mr. Bhatla, who's our Senior Vice President at Tata Consultancy Services. He heads the Public Services Business Unit and also the TCS North India operations. Tej has been part of TCS and our Tata family for 35 years. Under his leadership, TCS Public Services Unit has delivered several mission-critical projects under the Government of India, both for the federal government as well as governments in different states. If I may take this opportunity to name a few, I can say our Passport Seva project, our Aadhaar project, the Customs and Excise Management project, our India Post project, our Ayushman Bharat project. I think I can go on this. And I would really want to thank Tej for supporting, for joining us here. And I over to you, Tej, for starting off this session with your valuable remarks.
Thank you, Divya. Thank you for the introduction. A warm welcome to all of you. Good afternoon, and if you're not logging in from India, then good morning or good evening, depending on where you are logging in from. A very warm welcome to all of you to this session on Digital Personal Data Protection Act, its implications on all of us, and its implications on strategy if you are looking at it from a perspective of your organization as to what you need to do. This session is being organized by TCS MasterCraft But on behalf of TCS MasterCraft team, my co-panelists, who are very eminent personalities, and many of them have contributed personally towards shaping of the Digital Personal Data Protection Act. So on behalf of all of them and on my personal behalf, a warm welcome to all of you once again. I think thanks to GDPR and TCS's lead in trying to interpret what GDPR meant, I think many of us are at least familiar with this topic of privacy and what it involves for a individual or for other stakeholders, right? But I think after once GDPR took a lead, now several other countries, right? I mean, are in some shape or form implementing the specific regulations with respect to data privacy. European Union through GDPR definitely took a lead, and it kind of set a benchmark for others. And many other geographies, countries are now pioneering ahead in terms of what they need to do to protect their citizens' data and how to hold people accountable in case there was any untoward incident. I think that's where the whole context of this event is. All of you would probably know that India has also created a framework or finalized a framework, and this date, many of us will remember that 11th of August 2023, when that framework has actually now become an act after it's been passed by the parliament. Like GDPR, I mean, this act, of course, also has various provisions as to what would be the roles of different stakeholders with respect to this act, and what enterprises, individuals, and regulators need to do to stay compliant with the act, right? India, thanks to the digital revolution that has taken place in the last few years, I think the amount of information that enterprises or businesses, or even in many cases the government, right, collects from citizens is quite significant, right? So there is, the amount of information that you provide could correspond to your identity, could correspond to your educational qualification, could correspond to your demographics, a lot of such information that you might be providing for a specific service, right? To avail a specific service, regardless of whether that service is provided by government or by an enterprise. What this act entails is that, the enterprises as well as the government will need to put in sufficient safeguards to reasonably secure all the information that they are collecting from citizens, right, or their customers. Again, related to digitalization, I think as soon as India started focusing on Digital India, I think government took several initiatives to enhance security of the systems, right? How do you protect that the systems don't get breached, and there are no denial of service or any of those kind of events. So those security practices have already matured in India to a large extent. But I think with the act coming into play now, those security practices will need to now get extended to take care of the securing the data and keeping the data private, and not using the data beyond the purpose for which it's been intended to be, for a purpose for which it was intended to provide. So I think I will not take a lot of time. There are much better experts who are going to speak as we follow. So we have a very, very illustrious panel. comprising of Ranjit, Dr. Deepak Goel, Addepalli Srinivas, Dr. Sachin Lodha, all of them having a lot of expertise in the field in this particular domain. And as I said earlier, almost all of them have contributed in some way or the other in shaping the Digital Personal Data Protection Act. So without much ado, I now hand over to Divya to take the proceeding forward.
Thank you, Tej. I truly think that was a very good start for our session. And now let's move on to our next session, which is our panel discussion, which is going to be moderated by my colleague, Major Ranjit Goswami, who is the Global Head of Corporate Affairs at TCS. And it's responsible for managing the government relations and public policy for TCS globally. Ranjit has a diverse experience of more than 27 years, extending from defense and homeland security to e-governance and public policy. It gives me immense pride to introduce Ranjit that during his service in the Army, he has performed various strategic and operational duties and is also a recipient of the Governor's appreciation for his contribution to the state of Mizoram. With this, I would like to hand it over to you, Ranjit, and request you to moderate the session, please. Thank you.
Thank you, Divya, for those kind words and the kind introduction. Let me also start by thanking Tej for his opening remarks and setting the context on this very important topic today. Very good morning, good afternoon, and good evening to our viewers joining us from all over the world. I have a very impressive panel with me today. To introduce them, I'm going to start with Dr. Sachin Lodha. He is the Chief Scientist for Corporate Research and Innovation at TCS. Sachin heads privacy research and is working on diverse initiatives pertaining to trustworthy artificial intelligence, de-risking, cloud, quantum resilience, and privacy by design. As a scientist, Sachin understands the social and the financial relevance of data in today's world, and I'm hoping to get some interesting insights from him. Welcome, Dr. Sachin. Next, we are privileged to have with us Mr. Deepak Goel. He is the Deputy Director General at NIC and Senior Director at Ministry of Electronics and IT. He has served in the Ministry of Science and Technology earlier and has worked in legal department of NIC as well. In his current portfolio, with the Cyber Law and Data Governance Division, Deepak is leading the efforts in framing the rules for the Digital Personal Data Protection Act, something that the whole world is watching with great excitement and some anxiety, if I may add. We do hope to get some idea of what is coming for us, sir. Welcome. And finally, I have with me a very senior colleague, Addepalli Srinivas, Delivery Head for Digital India Product and Platform at TCS. This is where the rubber hits the road. He has contributed immensely to solutions and platforms, which is part of many of the Digital India projects delivered by TCS. He has extensive experience of similar large-scale implementations and is now gearing up for the same in India. Welcome, gentlemen, to this very important discussion. To start with, I'm going to request you all to reflect on the journey that this Act has seen since the Justice Shri Krishna Committee was formed in 2016 and how the Act finally has evolved today. I would request your unique perspective from your personal domains, inviting Sachin to go first. Sachin, over to you, please.
Thank you, Ranjit. It's great to be part of this panel and discussing something that is very close to my heart. As we as a TCS research and innovation team have been working on topic of data privacy for close to 2 decades. As you rightly said, I think if we look at the current DPDP Act, it has been about 7-year journey that started with that landmark 2017 judgment by our Supreme Court, which declared that right to privacy is a part of the fundamental right to life in India, and the right to information privacy is a part of this right. And then we have seen probably 4 different drafts of this, starting with Justice Shri Krishna Committee, the draft that was circulated in 2018. Then there was a bill that was introduced in Parliament in 2019. It was then called Personal Data Protection Bill. And then following that, if you all recall, there was a joint parliamentary committee which had a report on it in 2021. But however, this bill was withdrawn, and then we had a fresh draft, last year in 2022. And what we saw in August, that is 2 months ago, the Digital Personal Data Protection Bill is broadly based on this November draft. Of course, there are some changes. If I look at how this has evolved, I would say that compared to the 2019 version of the bill, the current DPDP Act is more modest and probably more pragmatic also. It has reduced obligations for both businesses and also for protection for consumers. I think regulatory structure is simpler because previous bill had Data Protection Authority as a very nodal body that was going to regulate in a big way. But this structure is much simpler here, where government has a lot more role to play. But at the same time, then there are some concerns about government having a lot more discretionary powers. Just to contrast further, if you look at three broad differentiations again here, I already talked about this reduction in rights. For example, previously we had something called as a data portability right or right to be forgotten right. And Tej indeed mentioned about GDPR, and these are rights that are part of GDPR. We don't have data portability right in the new act. And instead of right to be forgotten, now we have simple right to erasure, which probably is right thing to do because there is still debate about how to get right to be forgotten implemented, even in Europe and elsewhere. We probably have sharper focus on privacy now as a part of this act. So I think I like that piece. There are specific provisions. Previous act probably had more of a little tangential provisions. And I think instead of now DPA, we'll have Data Protection Board of India, DPB, that is going to play a role. It probably will help because maybe there are less touch points with the economy through this. So overall, I think it's a mixed bag. As I said, it's modest, pragmatic, but then it's not prescriptive. So there is certainly an element of discovery, both in terms of rule making that is currently ongoing in government, as well as when it comes to its implementation. And that's where I think we as a company, we as experts have a lot to offer. So with that, I'll close my remark, Ranjit, and really look forward to hearing everyone's thoughts on this. Thank you.
Thank you, Sachin, for giving that start. Coming to you, Deepak ji, I think Sachin has already given you thumbs up for the, the act which has finally been, which has come out now. Coming to you, Sachin spoke about it, and we've all seen that the draft has actually gone under multiple changes over the years, over the last 7 years. So share with us, what is your perspective of the final act which has been passed, and if you could share what is driving the change towards a more moderated form.
Thank you, Ranjit. Thank you, Tej and Sachin. Sachin has basically given a brief of the history of the act, so I need not to say anything onto the history. Means we all have been knowing what government has been gone through. The industry was trying to convey their thoughts on the 2019, the provisions of the 2019. So now we have a new Act and let's discuss about this 2023 Act. And so I'll just give a means what was our primary focus when we were when we withdrew this, and the government withdrew this in 2022, and then another 4 or 5 months were there. People slogged for having a draft, and the primary focus was one aim was to protect the rights of the individuals, and the second was to have a minimum disruption in the present IT ecosystem of the country. Another was to enhance the ease of living for the people and enhance the ease of doing the business. So I'm just focusing on those bullet points type of a thing. Another was to promote the digital economy. Means we have a setup of say $1 trillion digital economy by 2025. So that particular target is in mind. And then just to promote the innovation ecosystem. And database innovation ecosystem is one of those very key factors nowadays. So these were the few core factors that were at the center of those particular aspects when this particular bill was being drafted. So now here we are. So we are trying to say address the issues related to the usage of the data of the means the platforms, how they are trying to say interfere with the data, how the intermediaries are going to face the data to the citizens and other data processors also. And so the process of the rules is on the anvil. Let's see how it comes out. Thank you, Ranjit.
Thank you, Deepak, for a very candid submission. Coming to you, Addepalli, I'm sure you have been following this development as an implementer very closely. Want your views on how this evolution aligns with the other privacy laws around the world, which TCS has so proudly been involved in kind of leading the efforts for many of our customers. Over to you, Addepalli. I think you're on mute, Addepalli. Would you like to unmute yourself, please?
My bad. Yeah. See, I come from a banking kind of IT solutions for the last a decade, and I have been implementing all these flagship projects like whatever Pradhan Mantri Yojanas are coming up, right, in India. So I have seen walking with the Aadhaar and walk out with a bank account. I have implemented myself. I have implemented a walk-in with a Aadhaar and walk out with activated SIM, right? Besides this, we are seeing a lot of other digital India which is happening in terms of the super apps which are there available, for in your day-to-day life, like booking for a cab or 10 minutes grocery or even biometric systems which are used for attendance purpose. So if you see all these systems which have evolved over a decade, there is a lot of personal information which is being captured. Behind that, when I talk about personal data, it does not only mean about the demographic or name or age, but it also talks about what your search engine captures, what you're searching for. And there is a lot of analytics behind the whole scene to create your a persona, correct? And now we are talking about generative AI and those kind of things. So at this juncture, when this act comes, and particularly compared to the last time, it comes as a digital personal data privacy, is a remarkable thing, because that is what is the need of the hour for a country like India. And it also talks about few terms like, what is lawful processing? What is the right of a data principle, right? So what a breach means. So it is at this juncture of the digital India revolution, which we are talking about, that 1 trillion, digital economy, it has come at a right point of time, and it has come in a better format as from the last time, where it was about, it also involved about the physical documents. Now it is only about the digital, which is about IT systems and the way you protect the rights of the individual and the lawful processing. So that's my view as compared from a India perspective, as compared to the other countries and economy. It's India where the digital is happening. correct? We are talking about digital India, and India is, way ahead as far as the other countries. So definitely the form in which it has come at the right time, and it's a big welcome.
Thank you, Addepalli. I'm going to come back to you more on the India digital part, but let me get back to Sachin once. Sachin, what, in your view, could be the top few challenges for large organizations when it comes to implementation of such programs? And in India, I'm sure the organizations are gearing up for this, the rules which are so well being prepared by the government of India. Apart from large organizations, would it differ for the MSMEs? Share your views on that, please.
Yeah, Ranjit, this is a very pertinent questions, and I have participated in number of discussions already, with several of our customers in India on this. See, let's contrast this when Europe had GDPR in 2018. It was announced in 2016. Let's remember that they already had a data protection directive from 1995. And they had some level of preparedness, in terms of privacy implementation in their various organizations. So it was okay for them to sort of go full hog, and GDPR, as we know, is probably the strictest or most sort of empowering privacy regulation we have seen. But as I said, and also Deepak ji, Addepalli said that from India context point of view, there was a rethink, and then we have our DPDP Act. As I said, it's a bit modest, but still, to get that implementation right, organizations will have to do a number of things, and they are going to see certain challenges. I'll just probably highlight 3 major challenges here. See, one is going to be complexity, and this complexity has sort of different dimensions to it. One is certainly scale. A large organization and everything now going digital will have a large number of apps and a lot of data processing happening, that will require them to do and then data is also very heterogeneous, right? We probably have a majority of our data now in maybe multimedia form and not just as a tabular data like we used to have. This heterogeneity also is visible in terms of the deployment environments we see, right? Because typical IT in any organization is built in a very layered manner, we keep adding to what we already have, comes in. So I think this combination of scale, heterogeneity, of data environment is going to make that much for data discovery, understanding what data organization has, and also the purpose discovery, right? That why do we have this data? What do we do with it? So this data and purpose discovery are going to be, I think, key challenges in terms of getting the implementation going. But these are really the essential first steps that any organization will have to do. And when it comes to discovery part here, there is no silver bullet solution. They may have to use different techniques and methodologies to do it, so this has to be carefully thought through. The other second challenge that I want to highlight is sort of evolving regulatory landscape. So after GDPR came in 2018, I have heard this number. I'm just sharing it that 195 different countries had sort of their own version or some version of Privacy Act, and we just got added to that list. So for any organization that is doing business both in India and outside, this is to be considered. It's a lot of regulations that you need to comply to. And in fact, even with our own DPDP Act, it's quite possible, and I love to hear Deepak's thought on that, but it's quite possible that as we mature in this, we'll see also evolution in our own act, right? So regulations changing with time, regulations changing across geographies, a big challenge. So how do you implement in a sense that you are able to keep pace with it, and you are able to provide uniform, seamless customer experience that every organization has to think through. And last but not the least, again, a fact of digitalization and cyber world is that new technologies will keep coming and you need to adopt them, right? So just look at three big technologies that are being widely adopted. One is cloud, in fact, organizations are going beyond just single cloud to multi-cloud kind of deployments. Then we are adopting a lot of AI. And you look at AI is very data hungry, whereas privacy is big on minimization of data, So they are kind of contradictory. And then a lot of industry now, there is an adoption of IoT also, Internet of Things. Now, IoT actually generates high volume, high variety of data in a very high velocity manner, So in the light of such technologies coming, which are sort of creating, consuming data, processing it all over the world with multi-cloud kind of deployments, how do you future-proof the whole enterprise, your organization, so that the data protection and privacy, those goals can be readily met, So this goes back to how you architect your privacy by design, which is very important consideration. Okay, so I'll say that these three: complexity, evolving regulatory landscape, and constant influx of new technology seem to me like very, very pertinent challenge that every organization will have to look at. Thank you.
Well, thank you, Sachin. I think those are very important, suggestions for the organizations to be prepared today. You did allude to the time part of it, and that is something that even I had in mind to ask Deepak ji, if I could turn to you. Coming to the topic of time frames, can you share something, as to by when should organizations be ready? For example, data fiduciaries are expected to be ready and compliant to the Act. How do we see the time frame, evolving for this particular part? Also help us understand, and this is from my personal favorite as well, once the Act comes into force, do you foresee a change in the data usage pattern? And give us an example as to what that change could be.
Yeah, Ranjit, actually, whenever we listen an intelligent person like Sachin, we always get frightened. Means, are we into something? Means, is the elephant into the room? Means, just to bit a very small, I would not say answer, but response to the Sachin. Means, as an IT industry, if we can say, have a sort of, we have listened of, say, data discovery basically, and then data discovery basically happens for the, say, in terms of privacy, where my personal data is lying. So if we add to that the purpose discovery, what the data I am collecting and what it is being linked to, what purpose that particular data is going to serve. I think if we are able to solve these two things easily, I think quite the questions that Dr. Sachin has raised, they would get sort of means we may have some sort of an answer, or we can have some comfort. So now, Ranjit, coming to your question, means timelines. See, there is a legislative process after the enactment, or say after the president assent on the 11th of August. Now, the process is of making rules is on. And when the rules are there, so there would be public consultation, as happened with the bill. So whatever would get proposed, means industry, public, policymakers, all are ready, means are, or say can comment on it, can give us a sort of a government a pushback that okay, this is not the proper form of a, say, the government has proposed. So, and it needs to be modified. So there is a process of legislative consultation which we go through. This is a must process. So giving a timeline right now would be a tough, means when that particular rules would be coming. But as our minister has said in so many platforms that they are in making and they would be coming fast. But definitely there would be some gestation period for the industry to, say, consume and be compliant of that particular the DPDP rules. And then the rules and the act would basically be the total ecosystem which the industry will have to follow. Means albeit there would be some penalty clauses. This time it's only financial penalties, no criminal penalties as was in 2019. So that can give you a comfort. And then on the point of, say, evolving regulatory framework, I think we are into a position that the bill has been drafted in sort of an way that it is sort of a technology neutral. So as the technology evolves, as we grow into, means as we imbibe more technologies like IoT or AI or, say, multi-cloud operations. So I think we will be able to adapt to those rules also. And if required, I think there would not be much challenges in changing, or, say, I would say not changing, but evolution of those particular business practices into the rules. Means there is a requirement of a technical regulation type of a thing, of which everybody would become a compliant. And then that would facilitate, means that would give the industry and the individual the equal comfort as far as the data protection is concerned or the business ecosystem grows. So the next question that Ranjit you asked was, I think the behavioral pattern, how the industry is going to change. I think right now what is happening means as a data fiduciary or as a simple company, I would try to collect as much data as I want, irrespective of telling the user what is the purpose. I randomly tell them that how much, for how much time I'm going to store it. So these are the few practices which we have been doing over a period of time. There was a less of a grievance redressal system. So now after this enactment, when this comes into force, I think purpose limitation, data minimization, storage limitation, these type of things are to be built in into our daily type of in behavior. And one thing that is new is basically the grievance redressal part and the accountability of the data fiduciary. Till now, I think if the breach happens, we simply report and then really we are held accountable, at least in some of the geographies. So there is a sort of a penalty clause that's ranging from, say, 50 to 250 crores. And on the top of it, I think there is a clause of having blocking of those resources if the breach happens twice. So there is an accountability measure. So I'm pretty sure it means that companies who are processing, who are basically the data fiduciaries on the part, they will have to change the way they have been dealing with that data. They need to change the behavior. They will be changing the behavior patterns, means the way that data has been used. Means let's hope it works for good for everybody.
Right. Thank you, Deepak ji, for that. Addepalli, coming to you finally. Many of the large organizations have some measures in place to prepare for this transition, whereas we could feel that many of the organizations, the smaller, the MSME particularly, or even some of the large organizations for that matter, could still be in the planning phase. As an implementer and a consultant to those organizations, what would your advice be to how to prepare for this forthcoming transition?
Yeah. See, I just now learned that word purpose discovery. It's a very good word. So for all these organizations to implement this, first step would be the data discovery. Data discovery. What for you're collecting the data, how long you are going to store the data, the purpose, right? So that would be the first step for organizations to transition to this transition to this. Then second is there would be need of revisiting the business processes in terms of the business applications of the banks as well, like the PII data or the personal information data is visible to to the various roles of the organization. So what I mean, it should be visible only to the roles in that particular organization. So there will be a revisiting of the business applications in terms of role privileges to the access to the data. Third important would be the extremely sensitive data, which is like Aadhaar number, which is extremely sensitive data. So how do you store that data? So if you talk from the financial institutions point of view in India, many have already implemented a Aadhaar vault kind of thing to store this sensitive data. Maybe there will be an extension to this for a data vaulting for the other, very sensitive data which is being captured from the data principles. And fourth point, which Deepak sir also mentioned, is about the grievance redressal, which is something which today is only for a service which is being availed. But how you do from a personal data perspective is something which has to evolve to a great extent, So all the organizations to transition to this bill, the 4 steps are there: data discovery and the purpose. Second, revisit their business applications in terms of access to the personal data for the various roles within the organization. Because the definition of breach is like if the data of a person is, leaked, simple. That is where you get this all 250 crores and kind of penalties, which is to here also is a very, very, you'll be eating into the probably profits of the organization. So it's a very, very sensitive matter. And third, which I talked about, is the very personal data. And it is not only about Aadhaar number or card numbers in a financial world, but in the digital India, we are talking about your personal views. When you're sitting on a search engine, behind the scene, there is so much of data which is being collected, as Sachin already talked about. It's a huge data, right? So they're trying to create a persona of you, cross-sell products, right? So there will be a need to revisit the business application, whether it's a lawful processing. That is where I still feel that that is what is going to take a long legal aspect, and we would like to learn from Deepak sir when this lawful processing is there. And last point, which I talked about, is the grievance, which is an additional thing which every institution has to be prepared for, right? So this transition is definitely going to take a longer term as far as this act has to get implemented. But yes, I would like to add, it is not that something suddenly new has come, and various organizations have been started preparing for it. And as I talked about the Aadhaar Act, it protects us from the Aadhaar number getting breached. So, there is already a mechanism available. We have to probably keep building on top of it to, find ways for protecting the data principles' rights.
Right. Thank you, Addepalli. We also have some questions coming in from our audiences. But before that, I want to give actually a minute or two to each of the panelists to talk about a very important topic, consent management. This is something which has been widely discussed in multiple ways, in multiple forums. And Sachin, to start with you, can you share very briefly the challenges around consent management as you see them, and which tend to keep emerging, and how, in your view, can organizations best handle them at an architecture level?
Yeah, no, actually, Ranjit, very rightly said, consent, it has emerged as the most important tool in terms of providing sort of empowering individual and providing them control of their data sharing. So my view is that whatever may happen, whatever other fancy privacy technology may come in future, let's remember that consent management is going to stay. And with that view, I'm going to recommend that at most care and effort should be taken to implement consent management very well by an organization. Now, I also want to give one positive news on this, that there was a research work done in Carnegie Mellon University about 10 years back, and they have a paper called Privacy Paradox. And they basically have talked about that people actually share more personal data when you give them the tool like consent, because they feel like they are in control of their data sharing. So organizations should actually look at this as a positive development. Now, as Addepalli already mentioned, I think in terms of implementation for any consent management, basic step is to do purpose discovery and the data discovery. Without that, it's very difficult for you to sort of go back to your data principles, and tell them for what purpose you are using them their data, right? Now, all of this, again, we as a TCS team will recommend to have maybe a central consent manager, through which you implement this. And you probably can think of more of a API-based communication between this consent manager and different apps that you may have in your organization. I think let's also acknowledge that this implementation we are doing for India, our Indian fellow citizens, not all are tech savvy, and there could be language challenges also, right? So one thing very clear is that you have to, this is very clearly stated in our act, that the consent must be clear affirmative action, unconditional, unambiguous, and all that. So communication of that purpose with the data principle has to be very well done, and probably different language support might come in. And the last point I want to make is that consent fatigue is on horizon. Okay, imagine that we are consuming so many different even government digital services, and for each of them, if we have to provide so many consents, then at some point we are going to have consent fatigue. So in the light of that, if organizations themselves or through some third party, we can have some kind of consent recommender system, that this is how you should do your consent. I think that will ease the load on our fellow citizens, and they probably will do a good job. So those are my quick thoughts, Ranjit, on the consent part. Thank you.
Thank you, Sachin. And Deepak ji, coming to you, again on the subject of consent management, how do you feel the Act enables the data empowerment of the individuals, especially relating to the management of this consent?
I think, Ranjit, what is happening means what has been prescribed in the Act is that, as Sachin has already described, that the consent has to be in a very clear, affirmative, free, specific, informed, unconditional, unambiguous. All those type of words has been used in the Act, and then it has to be linked to a very specific purpose. And moreover, the most critical part in the Act is that the onus of proving that, okay, this particular consent was obtained from the individual for that specific purpose, the onus of doing that is onto the data fiduciary. And that has, this is very specific, and I don't think anywhere in the world this particular clause is there in any of the Act. So the onus of having, the onus that the data fiduciary has obtained the consent of an individual. So it has to be retained for a typical period also, so that if some breaches happens or some complaint of data processing, so he can show it off that, okay, we did it on the basis of a consent. So consent is basically become a sort of a bedrock. And then the another part is the withdrawal of the consent. To whatever the data I have given a consent to a typical data fiduciary, I can withdraw it at any point of time. And then when I withdraw it, so there is a provision that the data fiduciary will have to, say, erase that data also. So I think basically we have empowered quite a bit the individual about the data about himself. So it has been quite an attempt to empower him. The onus is on the industry to basically do away with this, means to grant this particular right to the individual. Let's see how it works out.
Right. Thank you, sir, on that. Addepalli, coming to you, before I take on some of the queries from the audience, I'm going to ask you a slightly different one over here. From a vulnerability perspective, how do you see the readiness of the Indian organizations, and how do you feel that they should actually be preparing to counter the threat of data breaches that could happen once after the act is enforced? So very quickly, in a minute or two, if you could share your views on that.
Yeah, very quick, I'll make it. See, today all matured organizations or the data fiduciaries which are there in India have a well IT system in place, audit mechanisms in place, right? Let's take a bank or telecom and all those things. So they are prepared from a IT security perspective. What is going to come in addition now, as rightly mentioned, is what is that PI data? What is that PI data which we have to protect? That's point number one. Point number two, the consent management. While consent management right starts from the purpose, so you need to have an entire life cycle management of the consent. And as our Dr. Sachin also said, it's going to be like a fatigue, to manage huge amount of consent. See, if you take the largest bank, we're talking about 24 crore consumers or the data principals, right? So how do you manage the entire consent lifecycle management? And third important aspect which will come is the data vault, which I talked about, because today the way the business applications are, we are primarily doing encryptions or database level encryptions or a file level encryptions to protect the data from getting breached. But you really need a mechanism to put it into a vault so that nobody other than the system or the person who has the right to access to that. So because again everything goes back to the threat of the penalty, which is the highest amount. And I think organizations have to really put a lot of effort in implementing this changes because of this act. From readiness from a readiness perspective, from a mature organizations, they have well established processes in place from IT audit, security, frequent audits. So all the mature organizations do have in the country. Thank you.
Thank you, Addepalli, on that. And let me of the questions. Some are very interesting. As for you, Deepak ji, which has come in, change once the act is enforced. I think a more candid version of that question would be: can somebody still sell me insurance?
Sorry, Ranjit, couldn't hear you.
Me, Deepak ji?
I couldn't hear you. Means what your is this a question for me?
I said the question is change. Once the act is enforced, what would change for a common man, or is there something that the person would experience?
I think, as I explained also, means you are in the control of the data, of your personal data. Right now, I don't know where my data is traveling, who is using my data, on what pretext. So I am getting empowered. And if I want to ask a data fiduciary, how did you get my data? So I can seek that the data trail. And if I feel that I am being violated, means personally, or say any provisions of this particular act has been violated, at least in respect of my personal data, so I can always go to the data protection board with a complaint and raise a complaint over there. I think this particular act is going to give them a better control on their own data and enhancing their privacy. And this was the core aim of this particular bill, and I think we hope to achieve that also.
Thank you, Deepak ji. To you, Sachin and Addepalli, either of you could take this. How big a challenge, or how economically, costly it's going to be a challenge for the medium and small enterprises in India to kind of become compliant to this act once it is enforced? Any one of you would like to take this, please?
Let me take this. So see, the three steps which we talked about is,
Sure.
it's about the data principles, personal data, right? And again, that word I really like, purpose discovery. If these two things are balanced properly, like what is the data you are collecting and what purpose you are collecting, then it's a question of changes from a business applications in terms of managing the consent and protecting the sensitive data. I think if you take these two parts, then and as I mentioned earlier, in some or the other forms, it's already there in the organization today. While the consent is there in star in terms and conditions, but it translates into a digital format. That is what happens, right? And from an applications point of view, if you see, then there will be a right available to the data principal to log into a business application and tell, please erase my data. Those kind of small changes will come in, but from an economical point of view, I don't think it's going to be a very big kind of investment. But yes, major significant data fiduciaries may have to do a introspection from end-to-end processes and the entire data discovery of the bank.
If I may come in here, so just to add to what Addepalli said, I think the popular notion is that data is an asset, which is true, but too much of it can become a liability. And I think this particular act actually is making organizations take very close look, careful look at the data they have, why they have, what they do with it, And I'm sure they are going to have some pleasant discoveries that they actually have unnecessary too much data. And if they get rid of that, they are actually going to reduce their liability, So in terms of the cost equation here, I won't be surprised if there are many gains also in here, where you are actually really making your overall data management very correct, and very tightly managed. So I think from long-term perspective, there are a lot of gains. So I think organizations should have a very positive perspective of this whole act and do the basic things, put basic processes in place. There are a lot of benefits that are coming downstream.
Thank you, Sachin, over there. And we still have more questions pouring in from the audience, but I'm afraid we are out of time now. Nevertheless, I'm sure the team will try to get back to the people who have posed the questions wherever it is possible. I very quickly want to thank all the panelists, Deepak ji, Dr. Sachin, Addepalli, for a very candid discussion over here. Before I hand it back to Divya, I also want to congratulate the entire organizing team for bringing us together for this brilliant discussions. Divya, congratulations to you and thank you. And over to you, please.
Right. Actually, thank you, Ranjit, for this awesome session. There were some very good key takeaways. One of the key takeaway that I can understand from at the end of this session is how a technology-led tools will play a very major role in helping organizations to comply with this act. And as Sachin rightly said, let data be your asset, but not a liability, right? So with this, I would want to end this session. Thank you once again, all our panelists and everybody who joined us together today. And I look forward to seeing you all again soon. Thank you. Stay well and stay safe.